defined with specificity. Then on the question of creation of new constitution, as regards the issue of creation of 70 new constituencies, in Declaration number 14, the High Court held that the Constitution of Kenya Amendment Bill is unconstitutional insofar as it proposed to predetermine the allocation of 70 more constituencies. It held it is unconstitutional for a Constitution of Kenya Amendment Bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. Indeed, that provision was in Clause 10 of the Amendment Bill. Article 89, Sub-Article 1 of the 2010 Constitution provides that there shall be 290 constituencies for the purposes of the election of members of the National Assembly provided in Article 97(1)(a). The respondents opposed to the appeal contested this part of the bill on the basis that it sought to amend Article 89(1) of the 2010 Constitution. Firstly, it is important to say that the High Court held that Article 89, Sub-Article 1 of the 2010 Constitution is not what they were calling an eternity clause, and they said that it is amenable to amendments subject to due process being followed. They stated as much at paragraph 670 of the judgment. I shall not go over it. It is clear that the court recognized, and rightly so in my view, that Article 89(1) of the 2010 Constitution is amenable to amendment. Having so recognized, was it unconstitutional for the Constitution of Kenya Amendment Bill to purport to create 70 more constituencies? In my view, once we appreciate that Wanjiku can seek to amend any provisions of the Constitution as long as the procedure set out in Articles 255 to 259 of the Constitution is adhered to, then the Kenyan people have the right to reduce or increase the number of constituencies to ensure that there is no underrepresentation. They can even vary the mandate of IEBC. Further, the functions of IEBC are spelled out in Section 4 of the Act, include delimitation of constituencies and wards in accordance with this Constitution. Black's Law Dictionary defines delimitation as the act of making a boundary or fixing a limit. Suffice to state that the Constitution of Kenya Amendment Bill 2020 did not seek to make boundaries or fix the limits of a boundary, but increase in the number of constituencies. The allocation of increased constituencies is not, in my view, delimitation. And clearly, the IEBC has no role to play in the creation of constituencies. And the upshot of the above analysis is that the second schedule to the Constitution of Kenya Amendment Bill 2020 in seeking to determine the creation of 70 more constituencies, in my view, not unconstitutional. We shall then look at the IEBC regulatory framework, and I will not go into great details on this, but suffice to state that the Constitution, the IEBC Act, the Elections Act make provision as regards the conduct of a referendum. And it is my considered opinion, and contrary to the findings of the High Court, that there is legislation pursuant to the Constitution, the Independent Electoral and Boundaries Commission Act and the Elections Act to govern the collection, presentation and verification of signatures, and a legal framework to govern the conduct of a referendum. Indeed, the High Court appreciated as much when at paragraph 783 of the judgment they stated as follows, and I quote, "Notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectation, values, principles, and objects, especially those in Article 10 of the Constitution, are met." End of quote. Besides, in the titles Alila and two others versus the Attorney General, the High Court had held, and I quote, "Secondly, I find that the Constitution has already set up a proper legislative framework for holding a referendum." And the court further stated, that is the High Court, further, there are explicit provisions in the Elections Act which govern the conduct of referendum in Kenya. End of quote. In the impugned judgment, the court had endorsed the findings in the Alila decision. At paragraph 603 of the judgment, it stated, "Though we have found that it is necessary to enact Referendum Act, we do not subscribe to the school of thought that absence of legislation implementing a provision of the Constitution renders such a provision inoperative and unenforceable. On that finding, we agree with the decision in titles Alila and two others." And at paragraph 6 of 6, the court stated, "It is, however, our view, and we hold that notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectation, values, principles, and objects are met." End of quote. In my view, it is surprising that having found so, the High Court proceeded to make a declaration to the effect that a declaration is hereby, this is what they said, "A declaration is hereby made that the absence of legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed." End of quote. In my view, it is my view that the IEBC existing statutory framework as well as the administrative procedures established therein were sufficient for purposes of carrying out a referendum. However, I am alive to the fact that there are two referendum bills that are pending before Parliament. It is my considered opinion that notwithstanding the fact that these bills have not been passed and fully debated by Parliament, it cannot be said that there was no regulatory framework to govern the conduct of a referenda. Consequently, it is my finding that there is legal framework to govern the collection, presentation, and verification of signatures, as well as the conduct of referenda. The other aspect is the issue of whether His Excellency, the President, was served with the petition and the hearing notices. And in my view, I think this is a fairly straightforward matter. There was at no point was the High Court told that shown any return of service or affidavit of service in respect of service upon His Excellency. What Mr. Oluchwer had said is that he had used an email address, and although Mr. Oluchwer had said he sued him in his personal capacity, that address seemed not to have been a personal address. But even notwithstanding that, it was imperative upon the court, once it came to the conclusion that the Attorney General could not appear for the President, to have ascertained at that point in time that His Excellency the President had been served with the hearing notice or with the petition. In my view, His Excellency the President was entitled to equality and freedom from discrimination as per the dictates of Article 27(1) of the Constitution, which provides for equality and freedom from discrimination. And then there is also Article 25(c), which provides for a fair trial as a fundamental right. In my view, the right to be heard is enshrined in the 2010 Constitution, and no one can be deprived of this right. This court has underscored the right to be heard in the decision of Onyango Olo versus the Attorney General, when it held that the principle of natural justice applies where ordinary people reasonably expect those making decisions which will affect others to act fairly, and they cannot act fairly and be seen to have acted fairly without giving an opportunity to be heard. A decision in breach of the rules of natural justice is not cured by holding that the decision would otherwise have been right, since if the principle of natural justice is violated, It matters not that the same decision would have been arrived at. Denial of the right to be heard renders any decision made null and void ab initio. In my view, it matters not that His Excellency Honorable Uhuru Muigai Kenyatta is the President of the Republic of Kenya. He is entitled to the protection of the law, as the law protects the weak as well as the strong. It was wrong for the High Court to have proceeded with the hearing and thereafter make adverse findings against His Excellency Honorable Uhuru Kenyatta without ascertaining whether he had been served, either with the petition and or the subsequent hearing notice or hearing notices. With regard to issues raised by Mr. Morara Omoke, whether the bill violated